All right, Ms. Myers, we'll call your case. So we're on the record in docket 2400229. That is people of the state of Michigan versus Cheyenne Myers. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And
Ms. Schroeder.
sorry. An assistant public defender, Aaron Schroeder, on behalf of Miss Myers. I appear here in the courtroom. Miss Myers appears remotely by Zoom with permission from the court.
And ma'am, you are Cheyenne Myers, is that correct?
Yes, sir.
All right. And you can hear me all right, Ms. Myers?
Yes, sir.
All right, this is the time set for a final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be an admission of responsibility to a civil infraction of careless driving under 257.626B.
And that is correct, Your Honor. After speaking with Miss Myers, that is my understanding.
So we'll amend, is this a ticket?
I believe it should be a
It
complaint.
was not a complaint, Your Honor.
So we'll add account 2 of careless. Oh, I'm sorry. That's a civil infraction.
Correct.
So we'll just amend count 1.
Mhm.
If I remember, that is a 3-point or 2-point?
What's
The
Careless
careless,
driving. I believe it's a
3-point.
3-point.
Yeah. 3-point. And what's it fine of? Yeah, I thought it was more than the regular.
It is. I believe it's 250, but let me double check, Your Honor. I have it written down. Yeah.
I think I thought it was the highest civil infraction.
It is. Careless driving is $215.
$15. All right, so Ms. Myers and Ms. Schroeder, that's your understanding. We'll amend count 1 to the careless driving under 257.626B. It's a 3-point ticket from the Secretary of State and a fine of $215. Is that your understanding, Ms. Schroeder?
That is my understanding, Your Honor, and my understanding from Ms. Myers is that she will require a little bit of time to pay to make that payment on those tickets.
All right, and you're gonna admit responsibility on behalf of your client, Ms. Schroeder?
Yes, Your Honor, I will.
And that's your understanding, Ms. Myers?
Yes, sir.
All right. All right. So just for purposes of making sure we're on the same, this is for conduct on March 30th, 2021 on I-496 at Homer Street in the city of Lansing. It is your admission on behalf of your client, Ms. Schroeder, that Ms. Myers, in violation of 257.626B, was careless driving on that date.
Yes, Your Honor.
Within the city of Lansing.
Yes, Your Honor.
All right. Anything towards this is admission on civil infraction.
No objection to anything. Your Honor.
Yeah. The 3-point violation the Secretary of State will assess the points. And how long does your client need to make payment to the city of Lansing with a $215 fine?
Miss, as long as my understanding is she probably need as long as the court is able to give her, I would ask.
All right. So
90 days?
Yeah, let's do 90 days. So we'll make it March, April, May, June. June 17. All right, so Ms. Myers, you have till June 17th to make the $215 payment to the city of Lansing. You have up until that date, so you can really set up your own plan, paying $10, $15, $20 a week, as long as it's all paid by June 17th of 2024. All right, ma'am?
Okay.
All right. Anything else for the record in 2400229 Ms. Wilson,
Nothing from the people.
Ms. Schroeder.
Nothing from the defense. Thank
You're
you.
all set, Ms. Myers. You can make that payment online, in person, or by Zoom. It should be all paid by June 17th. All right, ma'am?
Okay, thank you.
Thank you.
Yep.
Ms. Vanderzand, I believe, could you go next?
Vanderzand?
Yes.
All right, so we're on the record in docket 24-00404. That is people of the state of Michigan versus Rhonda Vanderzand. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And Assistant Public Defender Aaron Schroeder on behalf of Ms. Vanderzand, who is present and standing to my right.
And ma'am, you are Rhonda Vanderzand, is that correct? Thank you. This is the time set for a final pretrial on the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The people lack the necessary witnesses in this matter to move forward. The complaining witness in this matter, we attempted to subpoena, but we got a bad address. However, in contact with the complaining witness, I have been informed that had the subpoena been served properly, they still would have not complied. So I expect a motion from the defense.
Ms. Schroeder.
Thank you, Your Honor. At this time, the defense would make motion for dismissal of this matter. Thank you.
All right. Based on the representations of the people and the complaining victim was not subpoenaed, but once contact was made, indicated that they were not interested in going forward with the case. The motion to dismiss is granted. Without prejudice. So, Ms. Vandersand, that means that the motion is granted without prejudice, which means the people could reissue if they choose to, but realistically, for our purpose today, the case is dismissed, right, ma'am? All right.
Thank you, sir.
Anything else for the record in 24-00404? Ms. Wilson?
Nothing from the people.
Ms. Schroeder?
Nothing for the defense.
All right, thank you. Where did you want to go on next?
Mr. Feigelson says that he's
Yeah.
already on this run.
I understand. I give it-
Freeman Schneider?
Yeah.
Okay. All right. Thank you.
No, I'm good. Thanks, Tom.
All right, so we're on the record in docket 22-01220. That is people of the state of Michigan versus Mary Lou Riemann Schneider. And I have a pretrial, and then I have looks like a bond violation.
That's correct.
All right. Ms. Wilson, how are we proceeding?
Thank you. Your
Appearances
Honor.
for the
Oh,
record.
Abigail Wilson for the people.
Mr. Feigelson.
Yes, good honor. Good morning, Your Honor. Assistant Public Defender Stephen Feigels on behalf of the defendant, Your Honor. She's not present. I did check the hallway. I have not seen her. I have not heard from her in some time, so I'm not sure her whereabouts.
All right, Ms. Wilson, it would appear based on the representations of counsel, I have not seen, Ms. Riemann Schneider is not in the Zoom courtroom, physical courtroom. I don't see her in the regular courtroom. It would appear that the defendant has failed to appear for the pretrial and the bond violation. How did you want to proceed?
Thank you, Your Honor. First, if you remember, this was originally a felony case, and at the last hearing, Ms. Riemann Schneider appeared via Zoom because she was ill, and Your Honor did inform her that she needed to be here present in the courtroom for the pretrial today. Obviously, she's not here. This case is a 22 case, and that is in part because of Ms. Riemann Schneider's failure to appear in the past. So at this point, the people would be requesting an immediate bench warrant and bond forfeiture.
Mr. Feigelson, any comment?
None, Judge. I'll check the hallway one more time, see if she's.
All right. Yeah, this is not the court's first experience with Ms. Riemann Schneider, and she does have a fail to appear on this file on September 2nd of 2022. So at this time, I'll enter in an immediate bench warrant and bond forfeiture. Anything else for the record? 22-01220. Ms. Wilson.
Nothing from the people.
Mr. Fikes.
None, Your Honor.
Okay, you're all set. Thank you.
Thank you, Your Honor.
And then I think we're ready on Mr. Lauderdale.
Right, so we're on the record in docket. All right, so we're on the record in docket 22-00599. The parties, that's people of the state of Michigan versus Dwayne Lauderdale. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Lauderdale, who is present, standing to my right.
And sir, you are Dwayne Lauderdale, is that correct?
Correct.
Thank you. This is the time set for a final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I do not have the complaining witness here today. We did have a bad address for her. However, upon contacting her last week, I was informed again that even if she had received a subpoena, she would not be here today. So I expect a motion from the defense.
Ms. Schroeder.
Thank you, Your Honor. Based on those representations, defense at this time will be making motion for dismissal. Thank you.
So I'm in possession of a Nolly Pros or order of dismissal in 22-00599. The motion to dismiss is granted without prejudice, sir, which means the people could reissue if they choose to, but realistically today, for our purposes, the case is dismissed. All right, sir.
Thank you.
Anything else for the record? 22-00599, Ms. Wilson.
Nothing from the people.
Ms. Schroeder.
Nothing for the defense.
You're all set, Mr. Lauderdale. Thank you.
All right, thank you.
And then I think we're ready on Mr. Thomas.
That is correct.
All right, so we're on the record in docket 24-00186. That is people of the state of Michigan versus Eric Thomas. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Thomas, who is present, standing to my right.
And sir, you are Eric Thomas, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to the charge with a Killebrew to no objection from the people to YTA status if the defendant's deemed eligible. Yes.
That is a 90-day and or $500. There's a Killebrew of 76940 status.
Oh, YTA, yep.
HYT.
Pharmaceutical Trading Act status. So it's my understanding, Ms. Schroeder, of the plea agreement is that Mr. Thomas is going to plead as charged to count one, which is the reckless use of a firearm. It's punishable by 90 days and or $500. There's a Killebrew agreement that Mr. Thomas be referred to probation and sentenced on the charge with YTA status. Is that correct?
That is correct, Your Honor.
All right. May I inquire of your client of his advice of rights concerning this misdemeanor plea?
Yes, may.
All right, thank you. All right, Mr. Thomas, you understand that you are pleading guilty. The ultimate for this misdemeanor, the ultimate penalty is 90 days and or $500. Do you understand that, sir?
Yes, Your Honor.
There's an agreement between the attorneys that you receive YTA status on this case, which would mean that you receive a special status on this case if you're able to complete probation. Then they would treat it differently. Do you understand that?
Yes, sir.
All right. You understand that if I was to go in contrary to that Killebrew agreement between the lawyers, you'd have the opportunity to withdraw your plea. Do you understand that, sir?
Yes, sir.
Okay, thank you. All right. You have certain rights in this misdemeanor plea, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have any witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Aaron Schroeder, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, Your Honor.
You also have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted today, you'll claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'd be giving up the right to appeal any issues from a trial. Since you won't be having a trial today, you'll be pleading guilty instead. Is it your wish today to plead to the weapons charge, weapons, firearm, reckless use, with the understanding that there's an agreement?
Yes, Your Honor.
All right. I'm going to have you raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. I'm going to bring your attention back to December 11th of 2023 at the offense location in the city of Lansing. That would be specifically on 5828 Caverby Hill Drive. Does that sound about right?
Yes, Your Honor.
All right. On that day, did you recklessly or heedlessly or willfully or wantonly use, carry, handle, or discharge a certain firearm, a pistol, without caution and circumspection for the right, safety, and property of others?
Yes, Your Honor.
Why don't you tell me about that?
About
How'd that happen?
the whole thing with my incident, I ended up accidentally discharging a firearm and it ended up going into my ankle, which
All right.
fractured it.
So you were carrying and you discharged and you shot yourself.
Yes.
Do you know what kind of firearm that was?
A K8 KAHR 45.
So car 450?
Yes.
Okay. Anything concerning the factual basis, Ms. Wilson?
Maybe just, there were other people around, that, and we didn't make any precautions for their safety when handling the firearm.
Were there other people around?
Yes.
Okay. But he shot himself, so I mean, that's, all right. Any questions concerning the factual basis, Ms. Schroeder?
Mr. Thomas, when you were handling that firearm, you did so in a way that was not in a safe manner, correct?
What do you,
Well, you shot yourself.
yes.
I mean, and you did not do that on purpose, correct?
No, I didn't do
So you were handling the firearm in a way that caused it to go off, correct?
that. No, the angle that it was at, it was like
Okay,
this angle,
okay,
and the bullet ended up going down into my
ankle. Okay.
ended up grazing my calf.
You didn't have it in a holster or have a safety on it, would that be correct?
No, I had a holster, but the safety, it didn't have any safety or nothing.
Okay,
Right.
all right, thank you.
And your plan was not to shoot yourself. The plan was to do something other than that,
Yes.
to carry the weapon. Okay. Ms. Schroeder, anything towards the factual basis?
No, Your Honor, thank you.
All right. I believe that a factual basis has been made for a plea to charge a reckless use of a firearm concerning the facts and circumstances of the case. I'm going to refer to probation for the YTA status. So if you go to the 5th floor, they'll and go to the probation department. I think it's go to the right and all the way down. What they're going to do is answer all their questions, and they'll develop a report for me, and then we'll see what options are available to us at sentencing. Okay. So I'm going to refer to probation and set sentencing for
May 20th.
Thank you.
May 20th at 1:30. So this is set for sentencing on May 20th at 1:30. So if you go down and take care of all that, They'll develop a report for me, and we'll see what's available at the sentencing on May 20th at 1:30. You know that the continuing bond condition is not you not possess a firearm. You understand that?
Yes, Your Honor.
All right. All right. Let's see what's available to us on May 20th. All right, sir?
Yes, Your Honor.
All right. Anything else for the record? In 2400186, Ms. Wilson,
Nothing from the people.
Ms. Schroeder.
Nothing for defense.
All right, Mr. Thomas, we'll see you on that date.
Thank you, Your Honor.
All right, take care.
You
Go
take
back to
care.
probation. Okay.
And then I believe we're ready on Mr. Pettit.
All right, so we're on the record in docket 24004000343. That is the people of the state of Michigan versus Justin Pettit. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Schroeder.
Assistant Public Defender Aaron Schroeder on behalf of Mr. Pettit, who is present and standing to my right.
And sir, you are Justin Pettit, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a final pretrial in the matter. Ms. Wilson, how we proceeding?
Thank you, Your Honor. The complaining witness is not present today. I do see that we did submit a subpoena to her, and I have no indication that that subpoena was returned for a bad address or anything like that. So I expect a motion from the defense.
Ms. Schroeder.
Thank you, Your Honor. At this time, the defense would make motion for dismissal.
All right, Mr. Pettit, I'm going to grant the motion to dismiss. It's granted without prejudice, which means the people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, sir?
Thank you, sir.
All right. Anything else for the record in 2400343, Ms. Wilson?
Nothing from the people.
Ms. Schroeder.
Nothing from the defense.
All right, Mr. Pettit, you're all set. Thank you for your
Thank
appearance
you.
today.
All right, thank you. Take care.
You too. Thank you.
And then I think we're ready with Mr. Zany's client.
Right. Mr. Zaney, are you ready on Mr. Wilson?
Yes, Your Honor.
All right. Right, so we're on the record in docket 2303740. That is people of the state of Michigan versus Corey Wilson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Zane.
Good morning, Your Honor. Edward Zan on behalf of Mr. Wilson.
And sir, you are Corey Wilson, is that correct?
That's correct.
All right, you can hear me all right, Mr. Wilson?
Yes, Your Honor.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to need a final pretrial and a corresponding jury trial.
Okay. So we'll get a final pretrial date of
April 1st at 8:30.
and a corresponding jury trial.
April 15th at 8.
So we have set the final pretrial, which will be live in person on April 1st at 8:30. Jury trial set for April 15th at 8 o'clock. Anything else for the record in 2303740, Ms. Wilson?
Nothing from the people.
Mr. Zaney, any comment on either one of those dates? Do those work with your schedule?
The April 1st date, I'm out of town, Your Honor, but I can probably send coverage, so that doesn't bother me. The jury trial date I did not get from the court.
The jury trial date will be April 15th at 8 o'clock.
I can make that work, Your Honor. Thank you.
All right. All right. Thank you.
Have a good week.
With the understanding there may be coverage on April 1st. You have your dates, Mr. Wilson. They'll be sent to your last known address they'll also be sent to Mr. Zaney at his Grand River address. Anything else for the record, Mr. Zaney?
No, Your Honor.
All right. Then we'll see you on April 1st at 8:30. Thank you, everybody, for your appearance. So you're all set, Mr. Wilson. Thank you for your appearance.
Thank you, sir.
Thank you, Your Honor.
Thank you, Ms. Zaney.
do we have on Zoom? On the-
Sir, on the Zoom from the Ingham County Jail. Is that Mr. Kale?
I think it's Mr. Walker.
Sir, from the Ingham County Jail, can you identify yourself? Did you say Clifford Travis?
Yes, sir.
All right.
Oh, okay.
Mr. Travis. And then ma'am, on the iPhone, would you identify yourself?
Antonia Herrera.
Yes.
Ms. Herrera.
I believe Miss Sutter was outside with our last.
All right, Ms. Ferrera, we're ready to call your case. So we're on the record in docket 20-00913. That is People of the State of Michigan versus Antonia Herrera. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Schroeder.
And Assistant Public Defender Aaron Schroeder on behalf of Ms. Herrera.
And ma'am, you are Antonia Herrera, is that correct?
Correct.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a final pretrial and a corresponding jury trial.
Okay, we will set for a live final pretrial on
April 1st at 8:30.
and Ms. Schroeder, that was a fair statement.
That is correct, Your Honor. If I may just add one thing for the benefit of my client.
Sure.
And Ms. Herrera, I will be in contact with you later today. The purpose of that final pretrial is to get some documentation from you, and we'll discuss that further, okay?
Okay.
All right, thank you, Your Honor.
All right, and then, so we've set the final pretrial for live on April 1st at 8:30 and jury trial April 15th
At 8.
at 8.
15th. Thank you.
So Ms. Ferrera, you'll receive notice at that Reasoner Street address. Is that still a good address for you?
Yeah.
All right. Anything else for the record in docket 20-00913, Ms. Wilson?
Nothing from the people.
Ms. Schroeder?
Nothing for defense.
All right, Ms. Ferrera, you're all set. Thank you for your appearance today.
Thank you, Your Honor.
And then I know Miss.
HeyDudes.com.
032. That is People of the State of Michigan versus Quitario Ellis. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Assistant Public Defender Lauren Sutter on behalf of Mr. Ellis, who's standing to my right.
And sir, you are Quitario Ellis?
Yes, sir.
Thank you. This is the time set for a final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. So, I believe there has been an agreement worked out. The only thing that's causing kind of a hiccup is the issue of restitution. So if I can make a brief record on that.
Sure.
Okay, so, previously on, February 12th, we had adjourned to get some restitution information. On February 22nd, I called the manager of the property where the damage occurred, left a voicemail requesting a call back. I received nothing. On March 11th, I called again, left a message at the CMH main line. I was referred to Mr. Ellis's caseworker, who then referred me back to the same person I had called previously. I left a message and I have not received anything as of yet. So I have no restitution information at this time. I believe at this point, we're on our second final pre-trial, so I think we need to just proceed.
All right. So, Ms. Sutter, is that your understanding?
It is, Your Honor. I've been shared that information along the way. We did set for a second pretrial on February 12th for February 26th. At that time, we asked for a final pretrial to kind of give the property management group or, property owner a kind of deadline chance to submit any information. And yes, Ms. Wilson has been sharing with me along the way that nobody has yet to respond with her with anything meaningful or helpful. So at this point, I think we've given them all the chances.
And if I may add, the property manager was subpoenaed for the final pretrial here today, and he's not here.
All right. All right. And this has been, I have equaling my summary of notes to that effect. So I can confirm all that's been placed on the record. So Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. I believe at this time, there's going to be a deferred sentencing, 6 months of probation, and at the end of probation, the charge would be reduced to a civil infraction.
So is that a plea to the charge
I believe
then?
it's going to be a plea to, I believe it's currently charged as a 200 to 1,000. It'll be a plea to less than 200, and I can get that pack code here in a second.
MDOP. So we would amend count 1 or add a count 2, I think.
Add a count 2, I think.
Add a count 2. Okay. MDOP 200 or less.
Correct.
And would that be the MDOP of a building or would that?
Of a building, correct.
I guess that's MDOB.
Yeah.
Yeah.
That's 90 days.
That is a 93-day and or 500. And then I have the pack code whenever you're ready.
All right, what's the pack code for that?
750.3805.
And then the agreement is a deferred sentence.
Correct.
And we've specifically integrated as 6 months.
6 months. So you don't want this referred to probation, right?
I don't think so. If we have a set probation time, I think I don't think we need a.
We just come back
PSI.
on the sentencing date.
Yeah.
And if Mr. Ellis has been able, if everything's, we run him and everything's good, then it'll be a plea to a civil infraction.
Correct.
And specifically, Your Honor, I think we've chosen breach of the peace.
Yes. Yeah, that sounds right.
So deferred for 6 months. Accept responsibility to breach of the peace. That comes with a fine, right?
I believe so.
It does. It's $150 fine.
Perfect. All right, so Mr. Ellis, this is my understanding that this is going to be a plea to the 93-day misdemeanor and or $500 under 750.3805. What we're going to do is killabrew this for 6 months. And if you're able to, everything's good, no trouble for 6 months. What we're going to do is we'll take this and we'll accept responsibility to a civil infraction, which is like a speeding ticket for breach of the peace. And that'll come with a $150 fine. Okay. All right. So is that your understanding, Ms. Sutter?
It is.
All right. May I inquire of your client of his advice of rights concerning the misdemeanor plea?
Yes, Your Honor.
All right, thank you. So since you're pleading pleading guilty to the misdemeanor, we're going to walk you through those rights. If everything goes well in that misdemeanor, then Ms. Sutter will accept 6 months from now, we'll accept responsibility on the civil infraction. All right, sir?
Yes, sir.
Does that make sense?
Yes.
Okay. So this is in regards to, you have the following misdemeanor rights in count 2 of malicious destruction of a building under $200, ultimate penalty of 93 days and or $500. There's a killabrew agreement that we discussed concerning the 6 months deferred sentence, and I'm in line for that. Okay, I'm going to agree with that. So there would be no reason to withdraw your plea on that. That'll be your sentence today. Okay.
Okay.
All right. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented by Attorney Lauren Sutter today, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You understand that, sir?
Yes.
Okay. You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record, which is the agreement. And you'd give up the right to appeal any trial decision or trial rights because you won't be having a trial. You'll be pleading guilty instead. Is it your wish today to plead guilty to malicious destruction of a building under $200? And we have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I'm going to bring your attention back to July 27th of 2020 at 8112 East Jolly Road in the city of Lansing, Ingham County. At that time, on that date, were you present, sir?
Yes.
And at that time, at the 812 East Jolly Road, did you willfully or maliciously destroy or injure a building at that 812 East Jolly Road address? And was the price of any damage done under $200?
Yes.
Okay. And it's my understanding that belonged to community mental health. Is that correct?
Yes.
Okay. Anything towards a factual basis, Ms. Wilson?
Not from the people.
Ms. Sutter?
Nothing, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. And what I'm going to do is I'm going to accept the Killebrew agreement. We'll put you on 6 months. Okay. So it's a 6 months informal probation. We're going to defer sentence, and we'll defer sentence to
September 23rd at 1:30.
so September 23rd at 1:30.
Are you gonna have a probation?
I'm not. Yeah, I'm not. I mean, there's no reason to have them report to probation. So I don't want to give them any extra work than they have. So this is, Mr. Ellis, this is the plan. All right. You'll get notice from my court officer for that September 23rd at 1:30 date.
Okay.
If you show up, we're going to run you, and if you're able to stay out of trouble for the next 6 months, okay, what we're going to do on that, we're going to turn this into a civil infraction. All right.
Okay. Right now I have a misdemeanor, right?
Right, Seth?
Right now I have a misdemeanor, right?
Right now, until that sentencing, you have, it's kind of quasi. You have nothing right now. Okay. But if you don't show up for sentencing, you'll have a misdemeanor. You're right. Okay. And if you don't stay out of trouble, you'll have a misdemeanor.
Okay.
Right. So what we're doing is just a plan just to make sure you're out of trouble for the next 6 months. And then Ms. Sutter will admit responsibility on what essentially is a speeding ticket, a civil infraction, and it will go from there. All right, sir?
Okay.
So I will see you on September 23rd at 1:30. All right?
Yes, sir.
And just I'm
Right,
sorry,
Ms. Sutter?
apologize, Your Honor, just to make clear, is there any payments that he's needing to be making now within that 6 months?
No.
Okay, thank you.
Yeah. No, let's not, let's just keep it so that you're out of trouble, and then whatever, keep doing what you're doing, okay?
Roger.
Yeah, but we'll be getting here on September 23rd. If there is a problem, then there's gonna, we're gonna have that sentencing, and we'll have to address whatever problem is. I don't think there's gonna be one. So
There's not gonna be one.
all right, so on September 23rd, we'll get back here for sentencing. We'll get it done on that date, okay,
Yes,
sir?
sir.
All right. Anything else for the record in 21-01032, Ms. Wilson,
Not from people.
Ms. Sutter?
Nothing further.
All right, thank you, Mr. Ellis. We'll see you, we'll see you in September.
Thank
Okay.
you.
Yes, sir.
Yeah. I'll just hold on for 1 second.
All right, yeah. From the Ingham County Jail Post, sir, you're brand new to the Zoom courtroom. Could you identify yourself? All right, and sir, you are Clifford Travis, is that correct?
Yes, sir.
All right. And then, sir, are you Corey Blocker?
Yeah.
All right, thank you.
Yeah, I do. Okay. Great. Yeah. That
24-00112. That is People of the State of Michigan versus Teresa Martin.
Yes.
Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Ms. Martin, who's present staying to my right.
And ma'am, you are Teresa A. Martin, is that correct?
Yes, Your Honor.
Okay. This is the time set for an arraignment in the matter. And ma'am, what I'm going to do is walk you through why there was a bench warrant issued for you, okay? It was, the bench warrant was issued on February 26, 2024 by this court for failing to appear for a final pretrial. Final pretrial was set on January 29, 2024. And then I have you as failed to appear on February 26, 2024 with the date of the schedule. So on February 26th, you were not here. I don't know why you weren't here. We've checked the Ingham County Jail, and we don't have you as being in the Ingham County Jail on that date. Ms. Wilson, how did you want to proceed?
I would leave it to Your Honor's discretion.
All right, Ms. Schroeder.
Thank you, Your Honor. As to where she was on the 26th, she swears she was in jail. Maybe it wasn't this county's jail. I don't know. But she did show me paperwork from her notice that she had information written on it that she saw a magistrate. At some point, she admits that she may be confused on her dates. She's also been homeless, unhoused, so that is adding to I'm sure adding to some of the confusion. However, she did appear here today for what was originally scheduled to be the jury trial date. So she did appear for a court date. I would note that sorry.
Was she able to make bond?
She has PR bond, is what she. I don't believe she would be able to make any type of bond based on her living situation and employment status currently, Your Honor.
But I set bond for the fail to appear. So I don't know if she was incarcerated on that bond or if she was so the bond was set at 500 cash surety for the fail to appear for final pretrial. So she's not been arraigned on that, right?
Yeah, that is correct, Your Honor.
Right. All right, and then she showed up for the jury trial date to date. And the prosecutor has no position on bond concerning this matter.
I do not, Your Honor.
All right. So why don't we do this? Ms. Martin showed up today. I'm going to quash any bond that's currently out there. So we'll quash any bond. And we'll quash the cash bond, the 500 cash surety.
Your Honor, if I may make a request to the court.
Sure.
I would note that I originally back on the 26th did make an argument for dismissal based on the non-appearance of the prosecutor's witnesses. The reason that the court, I believe, declined to do that on that date is that Ms. Martin did not appear as well.
Right.
I'd ask the court to consider revisiting that. I do realize this is not originally a pretrial or final pretrial date, but based on their non-appearance of the previous final pretrial, I would ask the court to consider a dismissal. Thank you.
Ms. Wilson, I'll kind of leave it in your discretion.
I was going to leave it to your discretion.
Because it's my understanding that the victim was not here at the final pretrial.
That is correct.
But neither was Ms. Martin. And so we ran into the same problem that if Ms. Martin had been here, it would have been dismissed.
I've had no contact with the victim, so I guess I'll leave it to Your Honor's discretion.
But Ms. Martin, it generally is a bad idea to miscourt. Okay?
Oh, I know.
So,
If I
but-
would have known,
but- right.
I would have been here just like I am today.
But I think it's fair to say that you showed up today for jury trial, which is probably the best thing you could have done. Okay, because that told me that if there was an inconsistency that's been taken care of, we did have the final pretrial today. There was no victim at the final pretrial. Okay, and so what I'm going to do today is I'll entertain. The people appear that they are not able to move forward on the case because of the lack of subpoena for the final pretrial. Ms. Schroeder, did you want to you're requesting a motion to dismiss?
I am, Your Honor, and I believe that people were subpoenaed for the final pretrial, and there was no one appeared on the 26th. Thank you.
Based on the representations of counsel, my notes in the file, and the indication that the complaining victim was not present at final pretrial, I'll grant the motion to dismiss. So, Ms. Martin, what this means today is that the case is dismissed without prejudice, which means the people could reissue if they choose to, but realistically, for our purposes today, the case is dismissed. All right, ma'am?
Yes, sir.
All right. Anything else for the record in 24-00112, Ms. Wilson?
Nothing from the people.
Nothing from the defense.
Mr. Roder. All right. You're all set, Ms. Martin. Thank you for your appearance today.
Thank you.
All right.
All right, Mr. Slater, we're ready to call your case. We're on the record in docket 20-03342. That is People of the State of Michigan versus Alan Slater. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Slater, who's joining us via Zoom today.
And sir, you are Alan Slater, is that correct?
Yes, sir.
All right, you can hear me all right, Mr. Slater?
Sure can.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea today, and it will be a plea to count one, operating while intoxicated. The second offense notice would be dismissed. Counts 2 and 3, and the second offense notice for count 3 would be dismissed as well.
All right. So it's a plea to count one.
And then we have a sentencing agreement when you're ready.
So it's a plea to count one, dismiss second offense notice. Dismiss count 2. Dismiss count 3 and the second offense notice.
Correct.
All right, and then there's a sentencing agreement.
That is correct, Your Honor. We have there's a caliber agreement to, I believe, 4 months of probation. It's my understanding that Mr. Slater is currently in inpatient treatment in Mount Pleasant. So our thought was he would continue with the inpatient treatment with some Zoom reporting, and as long as he's complying with his inpatient treatment at the end of the 4 months, then his probation could be terminated successfully.
I think he's got to do an assessment.
He did complete one up in Mount Pleasant. I got that from them before we finalized all of this, so I can share that with probation.
All right. That would be for and do we know how long he's an inpatient?
So he's working in stages right now. He's almost at the end of his residential. He's moving to sober living in the next few weeks where he'll be for 3 months. And then after that, he'll be doing outpatient treatment. So we're expecting that about a month before probation ends, he'll be moving from sober living house to more independent living with outpatient treatment continuing. So he knows he's going to have to sign a whole bunch of ROIs along the way.
How long has he been an inpatient?
He has been there for approaching 60 days, Your Honor. I have the exact date written down. He's been working through a lot of stages there.
I've also completed a different rehab in Meridian for 30 days.
That's correct, Your Honor. He did one 30-day intensive inpatient residential before he moved to this one, where he's been for the past 30 days.
Okay. What's the name of the facility he's at now?
Switch tabs for that one, Your Honor. He is at behavioral health programs on Shepherd and Mount Pleasant. So it's the Saginaw Chippewa Indian Tribe of Michigan behavioral health programs.
All right.
He was originally admitted into that program on January 17th.
So what I'm gonna do is, I don't know how this works with probation. And I know that I have to give him, because he's got a prior, I've got to give him sometime, but it can be day for day. I can make it day for day for any inpatient. Just not sure how.
We still have to send it to my.
Yeah. Yeah,
I mean, if they're going off of, if Ms. Sutter supplies the eval and they go off that, could it be like accelerated? Or,
see, I don't know.
yeah, okay.
I don't know. I know I think the driving statute's gonna, it requires some, and then I know the second offense notice requires some entity, but that's easily taken care of with,
Well, and the second offense notice was dismissed.
right.
Mhm.
But I can do the day for day credit by inpatient and he's well
Sure.
along those lines. I'm just afraid we're gonna get hung up. The assessment's done.
Yep.
I'm not sure if anything else has to be done.
The snafu I foresaw perhaps coming was normally within 48 hours of plea, he'd have to meet with probation.
Right.
My only request is going to be to allow him to do that over the
Right.
phone as opposed to in person, given he is in treatment in Mount Pleasant.
Can you do that by Zoom?
He can, yeah, if probation can.
Yeah, I think probation can. So so I'm gonna follow the agreement because I think we're working on the underlying problem. The only caveat is to refer to probation within 48 hours. And Zoom I think is the only way to do that effectively.
And we could just get from the court what he's supposed to be zooming in, how exactly he does that.
Right.
Because at this point, I'm unaware of
And
it.
I'm
You might just need to call probation. and
Yeah,
get information.
I think you'd have to call probation.
Yeah.
And then I apologize, Your Honor, we really only have access to individual probation officers' numbers. Is there a general number he's supposed to call for that?
Numbers then.
483-4425.
483-4425. So that would be 517-483-4425.
Thank you.
Yeah, and then as long, you know, as that's more my concern, that probation's involved, that he's already inpatient, which is the whole, and then any I'm going to indicate for my notes that day for day credit be given.
Your Honor, I hate to interrupt.
Sure.
I see someone on Zoom that it appears they're in a car that's moving, and I just want to make sure they're not in the driver's spot moving.
Miss Riemann Schneider. I'll tell her there's a bench warrant for her while she's.
I already did.
Did you?
Okay.
She's on Zoom now.
Yeah, I'm more at this moment just concerned that she's driving while on Zoom.
She's not driving? She's not. Driving.
Okay.
So that's a good point.
Yes.
All right, so Mr. Slater, what we're gonna do is we're gonna refer you to probation as part of the sentencing agreement. You know that the ultimate penalty for what you're pleading to is 93 days and/or $100 to $500 and/or 360 hours community service. You know that's the ultimate penalty if I don't go along with the stated plea agreement, and I am going along with the plea agreement. All right, I'm telling you that up front. But you understand that if I didn't follow the plea agreement, you'd have the opportunity to withdraw your plea. Do you understand that?
Yes, Your Honor.
All right. All right. Ms. Sutter, may I inquire of your client of their misdemeanor rights?
Yes, Your Honor.
All right. All right. So the ultimate penalty, as indicated before, concerning this plea agreement that's been placed on the record, is 93 days and/or $100 to $500 and/or 360 hours of community service. You have the following rights concerning count one of this agreement. My understanding is that with a plea to count one, there's going to be a dismissal of the second offense notice concerning count one, a dismissal of count two and count three, and a dismissal of the second offense notice concerning count three. There's also an agreement that we've put on the record. Is that your understanding, Mr. Slater?
Yes, Your Honor.
All right. In this case, you have the following rights, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent till proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney Lauren Sutter, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, Your Honor.
You have the right to have the court order any witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been placed on the record or threats that it was not your choice to plead guilty. You'd also give up the right to appeal any trial issues, so because you won't be having a trial today, you'll be pleading guilty instead. Is it your intent today to plead guilty to count 1, operating while intoxicated?
Yes, Your Honor.
All right, I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, I'm gonna bring your attention back to July 20th of 2020 at 1315 South Pennsylvania Avenue in City of Lansing. Were you operating a motor vehicle on July 20th, 2020 at that Pennsylvania address? Were you operating a motor vehicle open to the public at that time at that location?
Yes, Your Honor, I was.
And did you later learn that you were operating the vehicle with over a 0.08 blood alcohol level?
Wow. Yes.
Did you later learn that, or were you made aware of that?
I later found that out. Yes, I was in
Okay.
the hospital.
All right, thank you. Anything towards the factual basis, Ms. Wilson?
None, Your Honor.
Ms. Sutter?
Nothing further.
All right. I find the factual basis to be knowing, voluntarily, and accurately made in count 1. We will refer to probation, and I've given you that number for Zoom probation. Since you're currently an inpatient, just continue with that plan. And I've indicated that you'll receive any day-for-day credit for any amount of time that you're in the facility or in the inpatient facility. But you should refer to probation, and we'll set, I think we have to set a sentencing date.
And Your Honor, before we do that, there is some restitution owed for the OWI cost recovery. I have filled out a restitution information form that
Right.
you would like me to approach with.
All
that.
right, and Ms. Sutter, have you seen that?
I was shown,
Yes.
yes.
All right. All right. I'll put that in the file. So there is restitution on this case, and that's to the city of Lansing.
Correct.
All right, I'll put that in the file, and we'll set a sentencing date for
May 20th at 1:30.
May 20th at 1:30.
And just, I was supposed to make it kind of clear, at that point, he may already be moving to outpatient at that time,
Right.
given how far out that is.
Do you want? See, that.
So I guess I suppose my question is, does
Or
the
do we
4
want to do
months
that?
begin then or now? Is the kind of main question.
That's a good question.
Because normally we'd set out that long for probation to determine what programming he needs on probation. We already kind of know exactly, he's doing more than they would ever require him to do on this.
Right. Well, let's put that, because he's already inpatient, and we know that, let's start the date now.
Okay.
So, because I want him to get credit for any time that he's been previously in. So start date would be March 18th.
Okay. Thank you.
I'm confused.
That seems reasonable.
We're gonna talk in a breakout room after
Right.
this, so I can explain a little bit
We
more.
just want to make sure that you're getting that the time starts now officially for any time spent in inpatient, which you're already at the facility, which would be something we would determine at sentencing. You've kind of jumped, you're ahead of us, which is a good thing.
No, I was just wondering, are you guys gonna take in consideration the past time that I've already did, or just from today?
Yes, I am taking that in consideration concerning day for day credit. But
Okay,
yes,
cool.
that obviously would be taken in consideration. I would take that into consideration as far as programming goes.
Right.
Right.
All right,
And
thank you.
just to be clear, Your Honor, so if you're granting day-for-day credit, would that be credit he's entitled to from time of arraignment until now as well?
Anytime he's an inpatient.
Thank you.
Yeah, anytime he's an inpatient would be, that's more substantive use of the time than being in jail, whatever be is the inpatient. So,
Right, and I kind of only asked because if he's been in treatment since January 7th, so if there's gonna be day-for-day credit, we're approaching 93 days. So we're already approaching the statutory max.
all right. So, but I mean, so he gets credit up to statutory max, I would think. I just want to make sure he gets credit for the inpatient and then, but the real underlying problem is to take care of him,
Right.
obviously.
And he's at,
The
so he was
programming
arraigned
involved.
he was arraigned on February 12th, so he's at 36 days right now. By the time we're approaching May, we're gonna be at or beyond the 93
Right.
days.
So let's do it. So let's make sure, let's day for day credit up to 80 days. How's that? And then, because he's kind of been programming on his own anyway.
Yeah, I've been in programming since January 28th. I had to go to a different facility waiting for a spot to open up here on the reservation. And now and so I'm over 4 months clean. I've been in.
So anyway you want to do it.
Right, well, my only hesitation as kind of defense attorney
Right.
at the 80 days was, I don't know that we can stop entitlement to credit at a chosen date.
Right.
If he's doing the time at the IOP, he's entitled to it. We can't just say no beyond this date. You can't.
Right. Yeah, I'll put day for day credit and then
Okay.
we'll figure, because I mean so I'm just gonna put day for day credit. So that on the judgment of sentence, it reads correctly.
Right,
But-
just because at some point, like as a defense attorney, I'd say, well, we've
Right.
got 93 days, Your Honor, we can't do
Right.
anything more.
Right, I know. And that's absolutely right. That's absolutely right. All right, so I put day for day credit concerning any time. That's really for the judgment of sentence because you're already in programming. But we will revisit this on May 20th at 1:30. And I put the restitution order in the file.
Perfect, thank you, Your Honor.
Anything else for the record in 20-03342, Ms. Wilson?
Nothing from the people.
Ms. Sutter?
Nothing further, Your Honor, other than Mr. Slater, go back into the breakout room after this.
Right. Ms. Sutter will explain this all in a breakout room, just so you know, there's more procedural aspects because of our probation. But as long as you contact probation and get on board with them, you're already in programming on some level. So that should be fine with the court, okay?
Okay, so I call probation now or after I get sentenced?
So I'm gonna go into the breakout room right now and explain what you're gonna do over the next 2 days, including
Right.
phone numbers.
Perfect.
Okay.
All right. You're all set, Mr. Slater, and then we'll put you in a breakout room with Ms. Sutter and she can explain to you what you'll need to do in regards to probation.
All right, thank you, Your Honor. Have a good day.
Thank you.
I guess if we want to do Mr. Block and
Yeah.
call Ms. Sutter's.
Oh, okay. I can,
So we'll do Mr. Blocker. We'll call your case. Order here. All right, so we're on the record in docket 23-03437. That is people of the state of Michigan versus Corey Blocker. Will the parties please introduce themselves for the record, Ms. Wilson?
Abigail Wilson for the people.
And sir, you are Corey Deshaun Blocker, is that correct?
Breathing human being, yes, I am.
All right, thank you. This is the time set for a competency review, and we've had a report indicating a evaluation review. Ms. Wilson, how did you want to proceed today?
I would stipulate to the findings of the report.
Okay, based on the findings of the report, Mr. Blocker, they have found you competent to stand trial. And that's a report that was dated March 8th, 2024. And Mr. Blocker, you would indicate you recall being evaluated for that report, is that correct?
Yes, I do.
All right. All right. So the people move to stipulate to the report.
That is correct.
All right. And Mr. Blocker, you understand that they found you competent to stand trial concerning this issue in the report. You understand that, sir?
Do.
All right. So I think we should probably reset this
Yes.
for at the earliest date. I've had some communication. Mr. Blocker has indicated that he has been awaiting evaluation and report, and he has at least 3 or 4 motions concerning his stay, his stay that has been presented to the prosecutor's office. So we'll set this at the soonest available date. Do you want to set for final pretrial?
Yeah.
Yeah.
I'm at 93 days already. I mean, I've been past 93 days. What are you talking about setting a trial? I'm past 93 days.
Right. Unfortunately, it gets told while we're waiting the report. All right. So now that I'm going to sign the order today, because we had to sign the competency report. I'm signing it today, and then we're setting it for the next available date for final pretrial to get this case moving. Because I know you've been awaiting the report. We've all been waiting the report.
Yes.
On some level. So we'll set it for final pretrial on
April 1st at 8:30.
April 1st at 8:30. Corresponding jury trial on April 15th.
Yes, at 8:05.
Right, so the competent company, I'll sign the order that the defendant is competent to stand trial based on the evaluation. And then, Ms. Wilson, if we do plan on, depending on what we plan on doing, Mr. Blocker certainly has time in.
Yeah.
And so if you get early notice of how we're heading in the file, please let the court know, and we'll entertain that at any time. Okay. So Mr. Blocker, we may be seeing you before that April 1st date in order to decide what to do with the file, but that's your final pretrial date. Okay, sir?
But what about me being stuck in jail and I had a PR bond since the first day, and I've been stuck in this jail without the PR bond.
That was told during the evaluation. Now that the evaluation's been done, I think that PR bond is still you were only being held to be evaluated, I would think.
I'm double checking right now.
Double check. Let's check on that, Mr. Blocker. I'll check on that. Because you are correct, sir. You were on a PR bond to begin with. I'm assuming you were being held for review.
It looks like he has some holds out of Eaton County and Grand Ledge.
All right. So you are PR bonded on this file. You're being held out of Eaton County.
Okay. Whatever.
Yeah, I'm not sure about that file. On this file, you are PR bonded. You are correct. All right.
Okay.
Oh, if it has bond denied. then
Probably for the evaluation.
Yeah, okay.
For the evaluation. So the bond, you were only being held on the evaluation. Now that it's been found competent, I will put you back on PR bond status. But that's probably not what's holding you. What's probably holding you is coming out of Eaton County.
Well, as long as I'm back on PR bond status, that will go from there.
Okay. All right. So anything else for the record in 23-03437, Ms. Wilson?
Nothing from the people.
All right, Mr. Blocker, we'll see you on that April 1st date, if not before. Thank you for your appearance today.
And then if we want to do Mr. Geller, he's going to be a Nolly for Global.
Okay.
And we're waiving his appearance today.
I'll be filling in for Miss Sutter.
And that confirms the notes in the file. All right, so we're on the record in docket 23-02461. That's People of the State of Michigan versus Cody Geller. Appearances for the record, Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
And Assistant Public Defender Aaron Schroeder, on behalf of Mr. Geller, stepping in for assigned counsel, Ms. Lauren Sutter.
All right. This is the time set for a pretrial in the matter. And I'll indicate for the record, this was adjourned several times out in global resolution and and looking at the defendant's presentation for global resolution and specialty court. Ms. Wilson.
Thank you, Your Honor. It's my understanding that Mr. Geller pled into sobriety court back on March 6th. So as part of the global resolution, the people would be dismissing this file in the interest of justice.
And that's your understanding, Ms. Schroeder.
Yes, that is my understanding, Your Honor.
And for the record, both myself and defense counsel waived Mr. Geller's appearance today.
That is correct.
Right, so I'm in possession. I'm not, because you're gonna sign the motion. Thank you. Thank you. I'm in possession of a motion for dismissal in the interest of justice for the global resolution on docket 23-02461. I will sign it without prejudice to that effect. Anything else for the record in 23-02461, Ms. Wilson?
Nothing from the people.
Ms. Schroeder?
Nothing from the defense, thank you.
All right, we're all set. Thank you for your appearance today.
And then I believe we're ready for Ms. Eichler. It's going to be probably a bench warrant.
Laura Eichler. All right, so we're on the record in docket 20-01725. That's People of the State of Michigan versus Laura Eichler. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Assistant Public Defender Aaron Schroeder, on behalf of Ms. Eichler, filling in for assigned counsel Lauren Sutter.
All right, this is the time set for pretrial in the matter. This is scheduled for 9 o'clock. It is now 10:29. I've checked the Zoom courtroom, the physical courtroom, and the waiting room. Ms. Eichler has failed to appear today. This was adjourned for a global resolution, post a plea in front of Circuit Court Judge Dragonchuk. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that Ms. Eichler also failed to appear for the plea that was set in front of Judge Dragonchuk and is currently on bench warrant status in that file as well. So we would be requesting similarly a bench warrant in this file.
Ms. Schroeder.
That is correct. At this point, Your Honor, I don't know where she is. Thank you.
All right. The court will issue a bench warrant and bond forfeiture for non-appearance. Anything else for the record in 20-01725? Ms. Wilson.
Nothing from the people.
Ms. Schroeder.
Nothing from the defense.
And I believe Mr. Feigelson's back from Ms. Rummage.
Is it? All right, Mr. Feigelson and Ms. Riemenschneider, we're ready to call your case. So we're on the record in docket 22-01220. That is people of the state of Michigan versus Mary Lou Riemenschneider. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Feigelson.
Yes, Your Honor. Good morning, Assistant Public Defender Stephen Feigelson, on behalf of Ms. Riemenschneider, who's present by way of Zoom this morning.
And ma'am, you are Mary Lou Riemenschneider, is that correct? You'll have to unmute yourself.
Yes, sir. I apologize.
All right. This was set for pretrial on March 18th. Was that right?
Yeah.
Yes.
Here this morning.
All right, yeah, but. So this is set for pretrial on March 18th, and then we had a failed to appear for that date, and it appears that that's somewhat been resolved. Ms. Wilson, how we proceeded?
Thank you, Your Honor. I believe that we're gonna ask for another pretrial on this. And the bond violation to follow as well.
All right. This is. What are the counts at now?
I believe it's just the final misdemeanor count of receiving and concealing.
RNC?
Yeah.
Okay. Is that a fair statement, Mr. Feigelson, to reset this for pretrial? Because we've had some appearance problems or late appearance problems, probably have that live.
All right, Your Honor.
Today.
Right.
We allowed her to appear by Zoom at the prelim for felony counts because she was allegedly ill. If that's still the case, I think we need some kind of documentation.
Right. Well,
I'm sorry.
Go ahead, Ms. Riemenschneider.
After this, I was going for my COVID test. I've been sick going on now 18 days. Fever, come and go of 103, body aches. I got no sense of smell. I got diarrhea. I was there. I do apologize, not trying to waste y'all time. I sent my fiance inside to see, because I didn't want to just come in and potentially infect anybody. So,
but you have no medical documentation. Okay, so Mr. Riemenschneider, do you have any medical documentation previous to this date? Because you've had more than one fail to appear today, other than today.
Sir, yeah, I've been to the doctor once, and they have me coming back in today at 1 to get a COVID test because they think I might be a long hauler.
Do you have an indication of your any documentation of your previous report to the doctor's office?
No, sir. I went for my normal checkup and I was fine, and then the next day I was sick. My daughter and I have been sick now going on 18 days. I got rash, hives all over. I don't know what's going on with me.
Your Honor, if I might add, sending the fiance in is not the
Right.
appropriate remedy here.
Right.
She should have been in contact with her attorney.
Yeah, Mr. Feigelson, you should be in contact with Mr. Feigelson. None of the other indirect contact through a third party is going to be acceptable.
I understand. I apologize.
Ms. Riemenschneider, what it's going to get is a bench warrant, and you want to avoid the bench warrant, right?
Yes, sir. Yes, sir, I do. I just want to not waste your guys' time and take care of this.
All right. Well, let's reset for pretrial. That's a live pretrial. If you cannot make it live, I'm going to need medical documentation to be provided to Mr. Feigelson, to the prosecutor, or else we're just going to assume that you're not here and we're going to issue a bench warrant for you. And the next bench warrant, it's going to be harder to quash that bench warrant because this is turning into a thing.
I understand. I go, like I said, for my COVID test today, and I can send that to all of you guys, the proof of it. I don't know how long it takes to get the results, but to show that I did
Right,
go
well-
and do that today.
Make sure Mr. Feigelson has that, definitely, he's your
Yes, sir.
attorney, and then he can provide any documentation to Ms. Wilson, all right?
Yes, sir.
Judge, did we get a new
All
date
right,
for
so-
the trial?
Yeah, I'm gonna do that. We'll reset the pretrial for
April 1st, that. 9.
April 1st at 9 o'clock.
Judge, can I get another date? I'm gonna be in a jury trial that morning, most likely still because of the holiday.
Yeah,
Okay.
so let's do another pretrial date. I can do earlier, Mr. Feigelson, if that'll work.
I can do it next Monday if the court's available next Monday.
Oh, yeah, let's do it. So March 25th.
That's correct, Your Honor.
Okay, March 25th at 9. So Ms. Riemenschneider, you should be here in person on March 25th at 9 live. If you
Okay.
can't be here, you need to provide some medical documentation for your non-appearance, or we'll just assume that a bench warrant's gonna be issued, all right?
Okay, so say I do have COVID, I just submit that and then we just go over Zoom, or how would that proceed?
Yeah, I would appear by Zoom, make sure Mr. Feigelson has any documentation, and Ms. Wilson, he would provide that documentation to Ms. Wilson.
We can log in at the time that we're
Yeah.
required to, so we're not in this position again. That would
Right.
be appreciated.
So just Ms. Riemenschneider, it's at 9 o'clock, so you probably should log on at 8:45.
Yes,
If
sir, and I
you're-
do
If you're
apologize.
logging on for Zoom, okay? Because
Yes, sir.
this is turning into a thing that you're always late, and then we're revisiting the file, and what's gonna happen is, at some point in time, we're just gonna issue a bench warrant because you weren't here on time, all right?
Yes, sir, and I do apologize
All
to all three of you. I did not mean to waste your time.
All right, so we'll set it for March 25th at 9 a.m. It's a week from today. Anything else for the record in 22-01-220, Ms. Wilson?
Nothing from the people.
Mr. Feigelson?
None, Your Honor. May I have a breakout room with Miss Remish? I need to tell her about a couple things I'd
Absolutely.
rather do in
And I'm gonna
private.
go ahead and quash the bench warrant that was done today. Just in
Thank you.
case. All right, we'll have Mr. Feigelson and Ms. Riemenschneider placed in a breakout room.
Mr. President, hour and a half.
Who's that?
Sit
I
in the
think
back.
he's a dog license.
Yeah, let's. Have you talked to Mr.
I
Weston?
have not, no.
Did you want to?
Yeah. Do you have any sort of?
They took. Mr. Travis off, didn't they?
He's gonna break out room.
On the record in docket 24-002-00027. That is people of the state of Michigan. I'm sorry. We're on the record in 24-00394. That's the people of the state of Michigan versus Tyler Wesley. So the parties please introduce themselves for the record. Ms. Wilson.
Abigail Wilson for the people.
And sir, you are Tyler Wesley, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I have received some documentation for compliance, so we will be dismissing this ticket.
And this is on a ticket. So based on the assistant prosecutor's representations, the ticket is dismissed without prejudice. today for compliance purposes. And Mr. Wesley, you should be all set today, okay?
Thank you.
All right. Anything else for the record? 24-00394, Ms. Wilson.
Nothing from the people.
You're all set, Mr. Wesley. Thank you. Thank you. Right, so we're on the record in docket 24-00546. That is people of the state of Michigan versus Clifford Travis. Appearances for the record, Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Travis, who's joining us via Polycom today.
And sir, once again, you are Clifford Travis, is that correct?
Yes, Your Honor.
Okay, and you can hear me all right, Mr. Travis?
Yes, Your Honor.
Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a request for a final pretrial and corresponding jury trial.
And that's a fair statement, Ms. Sutter?
It is, Your Honor, and then I'd like to briefly be heard on bond.
Okay. Final pretrial will be set on
April 1st at 8:30.
April 1st at 8:30. And corresponding jury trial, April 15th.
You said the 15th.
Yes, the 15th at 8. So the final pretrial will be live in person depending on April 1st at 8:30 and jury trial April 15th at 8 a.m. Ms. Sutter, you wanted to be heard on bond.
Yes, Your Honor. Mr. Travis currently has a bond that requires a tether. He has made application for assistance with that tether. However, I believe he's been deemed not indigent enough for it. Always an interesting determination when I'm the attorney appointed to the case, but nevertheless, that's what he was advised. It is the only thing keeping him in custody at this point. He can post, the bond does not afford the tether. He does have an address away from the complaining witness, and he and I have repeatedly gone over my warnings regarding no contact whatsoever of any kind for any reason. No one can tell him otherwise other than yourself. So I would make a request that at this stage, the tether requirement of his bond be lifted so that he can return to work and be released from custody between now and the hearing on the 1st.
Ms. Wilson.
Your Honor, given the assaultive nature of this offense, I do believe that tether is appropriate, but obviously it's up to your discretion.
And I would say that this just being a misdemeanor assaultive in nature case is not enough reason to have a GPS tether involved. There's no aggravating factors here. This is kind of just a run-of-the-mill case, and I don't believe that rises to the level of requiring a GPS tether.
Have you had any contact with the victim in this case, Ms.
Not-
Travis?
Not yet, Your Honor.
It's his spouse.
That's what it appears.
Married 2 years dating, in my understanding. Do you have any indication, Ms. Wilson, if there's a prior criminal history?
I believe there's an OWI, but there was an arrest for an assault conviction, but it was a non-cross.
I have no current employer at arraignment, and I arraigned him.
He was, I believe, the court was advised he was job seeking at the time. He's trying to get back into that.
Yeah, I'm willing to revisit this motion, but it's an assaultive crime. The no contact was put in because of it's an assaultive crime. I put in place victim or zone notification. I had no probation or parole at the time, no employer at the time. The address was confirmed, the Midwood address. If there's a place that I'm confirmed that Mr. Travis is working or seeking working, but I don't know the status of the GPS, but I'm not convinced right now that GPS is not required.
And just to be specific, Your Honor, is there a reason outside of this just being a assaultive charges or anything specific to Mr. Travis that is requiring a GPS tether?
Generally not, okay? Generally, a domestic assault, I think anybody should be, for an alleged assaultive conduct, their whereabouts should be known concerning the victim, and it's victim notification or zone notification. But this lends itself, the allegation also lends itself here that it has to do with cars and an assault in a car, and that it's a pretty scary situation, in my opinion. If you're able to work out the GPS, Mr. Travis obviously to me is indigent, or else you wouldn't be involved. So there should be funding for that. And I don't know if this is one of the situations where Mr. Travis breaks through the cracks. I am willing to revisit this on April 1st, but it would go to Mr. Travis if he's able to have an employer or something along those lines. He still has the no contact order. I'm not lifting the GPS victim notification or zone notification until I hear from the victim in this matter, because we haven't heard anything from the victim. So at this time, the motion to reduce bond, although I completely understand it, is denied. And then I will revisit this once we get some additional information. Anything else on 24-00546, Ms. Wilson?
Not from the people.
Ms. Sutter?
Nothing further.
All right. Mr. Travis, we will see you on that April 1st date, if not before.
You said what, sir?
Your next court date is April 1st. That's when we'll next see you in this court.
Correct.
Okay, can I speak with my attorney?
Yeah, once she's finished here, you can speak with her. She's got some cases in front of you.
So either hang out in the room for a few minutes for me to rejoin you. I have to handle one other thing, or I can schedule a polycom with you on Wednesday.
Okay. So when on the first, when gonna be on the first?
I didn't finish on the other.
I mean,
That's your next court.
your next court date will be April 1st, sir.
Wow. Okay, I'm through. I'm finished.
So if you want to, yeah, you're finished for right now unless you want to wait for a few minutes for me to become available to speak with you. I can't right now, but I will be in a few minutes. If you don't want to wait for a few minutes, you're free to leave and can step out of the room.
All right.
All right, so we're on the record in docket 24-00596. That is People of the State of Michigan versus Ashlyn Hunt. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Hunt, who's standing to my right.
And ma'am, you are Ashlyn Hunt, is that correct?
Yes, sir.
Thank you. This is the time set for pretrial in the matter. Ms. Wilson, how are we proceeding?
I would defer, Your Honor.
Ms. Sutter.
Thank you, Your Honor. At this time, there's been no offers made as of yet. We'd be requesting a final pretrial jury trial.
So we'll set the final pretrial for April 1st at 8:30 and the jury trial for April 15th at 8. So we've said it, that final pretrial will be live just like today, Ms. Hunt. And then we'll see if we need a jury trial after that. Anything else for the record on docket 24-00596, Ms. Wilson?
Nothing, people.
Ms. Sutter.
Just a question, Your Honor. Ms. Hunt wasn't sure whether she'd gotten something in the mail about fingerprints. Was she supposed to have those done or have they already been completed?
They are not done.
They are not done. I have the order.
Okay. She wasn't sure about that, so we'll have her go down and do them today.
Yeah. I have an order for fingerprints in the file itself. So if you can take care of that today, that should be done previous to the pretrial. Anything else for the record in 24-00596, Ms. Sutter?
Nothing further. Thank you.
All right, thank you. That's all set. We'll see you on that April 1st date. All right, ma'am?
Thank you.
Walker?
I don't remember there being, let me double check.
I'm wondering if you could just,
I think technically it would have to be set out for victim notification, but
yeah, I mean, because it is.
it is, yeah.
I think you're right.
Yeah.
I would just, that's fair. I would get some chance to keep earning credit.
All right. So we're on the record in docket 24-00027. That is People of the State of Michigan versus Jamone Joseph Walker. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Assistant Public Defender Aaron Schroeder on behalf of Mr. Walker, who is present and standing to my right.
And sir, you are Jamone J. Walker?
Yes, that's
Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a plea to the charge. And there is a Killebrew that on this file alone, no PA 53s or witness interference will be pursued from the people.
And that is correct, Your Honor.
So it's a Killebrew of no PA 53. Witness interference. And that's your understanding, Ms. Schroeder?
That is, Your Honor.
May I inquire of your client of his advice of rights on this misdemeanor plea?
You may.
Sir, you understand that the count 1 charge of illegal entry comes with a misdemeanor of 90 days and or $500 a potential consequence to this. Do you understand that, sir?
Yes.
All right. You understand you have some rights in this misdemeanor file, and I'll walk you through each one of those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Aaron Schroeder, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes.
You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal any issues concerning trial, because you won't be having a trial. You'll be pleading guilty instead. Is it your desire today to plead guilty to the illegal entry in count 1?
Yes, Your Honor.
I'm gonna have you raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I'm gonna bring your attention back to November 20th of 2023 at 5834 Monticello in the city of Lansing, Ingham County. Were you present on November 20th, 2023 at that Monticello address in the city of Lansing?
Yes.
Okay. And at that time, did you enter without permission a home that was located on 5834 Monticello?
Yes.
Okay. And you did so knowing that you did not have permission from the owner of the home to enter it. Is that correct?
Yes.
All right. Anything towards a factual basis, Ms. Wilson,
Half from the people.
Ms. Schroeder?
Now for the defense.
I find the factual basis to be knowing, voluntarily, and accurately made. I'll accept the factual basis for the plea. We're going to refer this to probation. Is that correct?
I can't remember what time Mr. Walker was incarcerated, but he might be approaching
His 93
his
days.
93 days. I do believe that there does need to be at least a date set out for victim notification under the Crime Victim Rights Act. for
Right.
Potential statement and sentencing.
He was arraigned in, I have him arraigned on January 16th.
Yes, I've been incarcerated since January 12th.
And I know he has other holds on other files. So it's not like we're gonna be released or something.
So let's, because we're setting the sentencings in May, right?
I think that was the last, yeah, which is obviously beyond the 93
Right,
days.
I think, so I think we've got to get him before the 93.
I mean, if we're not doing a PSI, can we do earlier than that?
Yeah, so.
I don't know.
Like 2 weeks for the.
We don't know.
Yeah, because
He's got like-
We can't go, because he'll just be PR bonded after his statutory time.
I tried to schedule something earlier last week. And we should have given at least the 6 weeks, but she was at the 6 week mark. You were unavailable.
I think he's like at 67 days if we're counting from the 12th of incarceration.
He should have PR'd on this in 7 days though, so.
But the bond wasn't changed, so he's entitled to the credit.
I've got a bond of 3,000 cash surety.
I believe he was arraigned on all 3 files and a
Yeah.
cash bond was put on all of them, if I remember
So
correctly.
the other files are what's holding him. He would have PR'd on a misdemeanor automatically in 7 days.
But-
In Ingham counties.
That's their policy, but we did not change bond here, so he still gets his 67 days.
Right.
He'll be at 130 by May 20th.
Yes.
So I can PR bond him today
Okay.
on this file. With credit. Yeah, that would give us out of the 93 day on this file. And allow us to be sentenced for May sentencing, but he's being held on the other files.
Yeah, that's the issue.
So the
Yeah.
PR would just give him dead time. It would,
Yeah.
it would harm
Right.
him, not help
Yeah.
him.
That's the problem, is
Right.
he's not collecting any
Not
time
gonna
on it,
get any time on this. I
right?
mean,
So I mean,
if we're just, sorry, Your Honor.
yeah, I just don't want him to go. I want him to get his time in.
Yep.
But I don't, but we've got to set it for sentencing, because we have to notify the victim, if there is a victim. We don't,
I mean.
Yes.
But
Yes.
his probation, because probation is the reason it has to be set out so far, right? And I apologize.
Yeah, no, so if we're not referring to probation then,
If you're just bypassing them altogether.
yeah, because
You don't
it's
need-
gonna
don't
be a
have to have it.
jail sentence. He's got his time in.
Yeah, it doesn't, I think it's just victim notification there.
well, let's not refer him to probation.
Yep. Mhm.
Let's just set it.
Set it. Mhm.
Set it for victim notification for sometime before, he's got 67 in now, you said?
As of today, yeah.
As of today, yes.
So let's do it three weeks from
3 weeks
today.
works, yep.
Okay.
So let's do a sentencing 3 weeks from today with no probation, but that'll give the prosecutor's office a chance to contact the victim. And he still keeps getting his day for day credit.
Yeah.
Yes.
Well, it doesn't.
So we've set your sentencing for April 8th at 1:30. I'm not, this is not referred to probation. And it's not a DV, so I mean, you don't, the only thing is we are setting it for victim notification.
And he'll either you will probably come or Rick, Your Honor.
All right.
Thank you.
Okay, you're not-
So that would be the notice. All right. All right. Anything else for the record? 24-00027, Ms. Wilson,
Happen to people.
Ms. Schroeder.
Not from the defense, thank you.
All right, Mr. Walker, we'll see you on April 8th at 1:30. Okay, sir? All right, thank you.
All right. Yeah. but at least we- Okay. So we'll see you when you come back on. Okay. All right, take care.